Hello, everyone. Welcome to our webinar today. I'm showing 2 o'clock Eastern time, so we're going to go ahead and get started. My name is Patricia Julianell. I'm the Senior Director for Program Advancement and Legal Affairs at Schoolhouse Connection, and I'm joined by my colleague, Karen. Karen, do you want to introduce yourself?
Hello, everyone. I'm Karen Rice. I'm the Senior Program Manager of Education Initiatives at Schoolhouse. And I apologize, but for some reason I cannot turn on my camera. So I am here and I'm glad to be with you all today.
Fair enough. So welcome to all of you. This is a webinar format, even though it's on Zoom. So we have the Q&A panel where you will be able to enter your questions. We're going to have plenty of time for your questions today. So please feel free to type in questions anytime. And we'll get to those when we stop for questions. Also, Karen has put into the chat box a link for this PowerPoint. So if you'd like to access that and download it, you can do that on the link that she put into the chat. So that is going to get us started. We are here, of course, to talk about unaccompanied youth. I assume that most of you are familiar with Schoolhouse Connection since you're on this webinar with us, but we are a national nonprofit organization working to overcome homelessness through education. We do a lot of work just like this, trainings and technical assistance, policy, and we also have a scholarship program, which I'll provide more information about later. We also wanted to use this opportunity for shameless marketing that we will be launching online modules for school staff training. We're going to be piloting those in the next few weeks and launching them in the first quarter of next year. So if you want more information about those online modules, including what they contain and how much they cost, you can visit that website that's on the slide. Now for the webinar. What we are going to do today is really going to be based entirely on scenarios. Rather than just go through a PowerPoint of a lot of information about unaccompanied youth, we thought it would be best to have some scenarios and kind of respond to those scenarios. We will have some polls for you. We'll provide you with some tools. And like I said, we'll have plenty of time for your Q&A as well, or your Q&A. So let's jump right in. First scenario, we have a 17-year-old senior who has moved in with her boyfriend's family. She's sharing her boyfriend's room and trying to enroll in her boyfriend's high school. Her parents say they want her to come home and do not want her to enroll in her boyfriend's school. The student says she can't return to that home. And the principal of her boyfriend's school says she cannot enroll there and she just needs to go home. So let's get started with our first poll. What do you think? Can she enroll in her boyfriend's school? You could say yes, no, or not sure. I see your answers pouring in. Thank you very much for that. We'll give you a few more seconds to answer. Okay, most of you have answered, so I'm going to give about 2 more seconds and then close the poll. Vote now or forever hold your peace. Okay, so we have most of you saying yes, about 2/3 of you saying yes. 14% are saying no, and 20% are not sure, so that's perfect. That's why we're here. Let's see, let me put the poll away. Let's look at what we have in our toolbox. So rather than just give you an answer, which I could do, let's look at what we actually have as tools to answer this question. So for this particular question, we probably need to rely pretty heavily on the McKinney-Vento Act. So that's why we have lots and lots of citations here from the McKinney-Vento Act. The first question is, does the McKinney-Vento Act even apply? So the first question is this student homeless under the definition of under McKinney-Vento, and would she be considered an unaccompanied youth? So if we hop back here, we see she's moved in with her boyfriend's family. She's sharing his room. Her parents say they want her to come home. She just says she can't return to that home. So there's a lot of information that we don't have, but we do know that she's staying with somebody who is not her legal guardian or parent. We do know that she's sharing a room with somebody else. It sounds like it might be a little bit unstable because the student's saying she can't return home, but we don't really know why yet. The parents want her to come home, but we don't exactly know what's going on. So given the sort of just vagueness of what's happening in this situation, it certainly does not sound very stable to me. It doesn't sound like something where I feel confident that this person is living in a fixed, regular, and adequate nighttime residence where she's going to be able to stay and not going to get kicked out. So at least based on the information we have, it seems to me like she does meet the definition of homeless and unaccompanied in the McKinney-Vento Act. Once we get past that, we know that the McKinney-Vento Act requires immediate enrollment. We also know that the liaison is the person who has the legal authority and responsibility to determine eligibility. So if I'm the liaison and I think she is eligible and the principal thinks she is not eligible, my determination is the determination that's going to hold there. So if I'm saying that she is eligible, then we need to go ahead and enroll her immediately, which of course is specifically defined to include participating fully in school activities. The McKinney-Vento Act also requires schools to give priority to the wishes of unaccompanied youth in regard to school selection and enrollment. So this is something that is unlike other education laws, and sometimes it feels strange and uncomfortable to say, well, the parents want her to go to this school, but she wants to go to the other school. We actually have to give priority to her wishes. So in this case, she would actually have the ability and the right to enroll in her boyfriend's school under the McKinney-Vento Act. If we need to, we're probably going to need to have some conversations with the parents. They're going to be unhappy, certainly, about her being enrolled in her boyfriend's school, but that it really is what the law requires. And even if the youth wanted to dispute this, so if the principal's saying, no, you can't enroll in that school, and maybe the liaison is also saying, no, you can't enroll in that school, the youth herself actually could dispute that and say, no, I think I do have the right to enroll in the school. And McKinney-Vento requires that youth actually be given access to that dispute process under McKinney-Vento. So we have lots and lots of tools in our toolbox to help us get through this question and get to the answer, which at least based on the information we have, is that yes, she can enroll in that school. Now, there might be other facts that we don't know yet that we find out later, but that's what we know so far. So let's take this a little further, and I see we have a couple questions coming in, so we're going to get to questions, but let's take this one a little further first. So after we get this student into our school, have the opportunity to talk to her and get to know her a little bit, we find out that her parents are struggling with addiction and mental illness, and she ran away because she does not want to raise her child in that environment. She is pregnant. So that's really what's going on, at least, as we are able to have more conversations with her and get more details about what's happening. But with all this drama that's been happening with her parents, wanting her in a certain school, with her moving in with her boyfriend and moving around, she's missed 15 days of school this semester, and she's at risk of not earning credits this semester. So what's in your toolbox for a McKinney-Vento student who maybe has missed a lot of school and is at risk of not earning credits? Well, let me tell you what's in your toolbox. The McKinney-Vento Act requires states to have procedures to identify and remove barriers that prevent McKinney-Vento students from getting credit for full or partial work that they may have completed. So even if you don't have anything in place typically in a school or a district for partial credits, the McKinney-Vento Act is going to require you to have something in place for McKinney-Vento students. Just because she missed 15 days, she still needs to be able to get credit for the work she has done, and hopefully also to be able to make up the days that she missed so that she can stay on track for graduation. She's 17, she's a senior, she's pregnant. The last thing we want to do is have her drop out of school now because she thinks she's not going to get credits because of the days that she had to miss. So there is a requirement to provide partial credit. We have a number of resources on our website to help figure out how to do credits, how to accept them, how to kind of divide them up and apportion them. So you can click on those links when you download the PowerPoint, and you'll be able to access more tools in your toolbox for making sure that the student gets credit for the work she's done this semester. So let's keep going with this student. Her living situation with her boyfriend has fallen apart, and now she starts bouncing among friends' homes. But she desperately needs a stable place to live, especially after her child is born. Now, she would like to apply to a maternity housing program, but she needs her ID and her birth certificate to apply to that program. Her parents have her ID and her birth certificate, and they will not give them to her. So what's in your toolbox about this one? How can we get her ID and birth certificate for her or help her with that? Well, there's a couple of things in your toolbox. The first thing is a number of states allow unaccompanied youth to access vital documents on their own. They don't need a parent signature, and they don't even need to pay a fee for that. And we have a document on our website, that link will take you to it, that will tell you what's in place in your state for her to be able to get her ID or her birth certificate. There's also a homeless youth legal network that was created by the American Bar Association, where they can help connect youth to attorneys to help them with issues outside of school. So for example, issues around getting their IDs or other things. So we have a link for you there. Another thing which I didn't put on the slide is thinking about, is her birth certificate in her school records? We're going to talk in a few slides about what access she might have to actually being able to get a hold of her own school records and provide those to this maternity group home if her birth certificate is in there. There also might be a way to convince the maternity group home to let her school ID function as an ID rather than, a driver's license or state ID. Her school ID should be sufficient identification. They just need to know who she is, and that should be sufficient. So a few other things in your toolbox there. Let's keep going with the same scenario. So now she's completing paperwork to get herself and her child enrolled in Early Head Start. So as a pregnant woman, she can enroll in Early Head Start now. She does not have to wait for the child to be born. So she wants to enroll in Early Head Start, but she's still working on this ID and birth certificate thing. She doesn't have those documents yet. And the Early Head Start program told her to come back when she has her documents. So here's another poll for you. Can she enroll in Early Head Start without those documents? What do you think? Oh, I see the answers coming in. I see a lot of correct answers coming in. All right. Most people have voted. I'll give you a few more seconds before I close the poll. Okay, you are mostly all correct. The answer is yes. She can enroll in Early Head Start without those documents, and let me tell you why. So there are rules that govern Head Start programs. They're called Head Start Program Performance Standards. And regardless of whether this Head Start is run by a local educational agency or a school district, or whether it's a completely independent program, they're going to have to follow the program performance standards. And those program performance standards say that they must allow McKinney-Vento children and families to attend for up to 90 days without immunization records, so that they can have time to get those immunization records together. They also can't require them to provide documents confirming age if doing so would be a barrier to enrollment. So there's your birth certificate piece. We do have information on our website about all of these provisions under Head Start that you can take a look at. And then another thing to keep in mind is if this particular Early Head Start program is actually run by the school district, then they're going to have to follow McKinney-Vento as well. So any Head Start program that's administered or funded by your local educational agency would have to follow McKinney-Vento as well. So we didn't say on the slide whether this is a local educational agency program or not. We don't know. So either way, they're going to have to follow Head Start's rules no matter what. And so either way, she's going to be able to enroll in this program. All right, let's do one more piece of this scenario and then we'll jump in for some questions and then we'll come back to more scenarios. So just to follow along with this kind of early childhood aspect of it, she's also doing the paperwork for subsidized childcare. She's working through her local CCR&R, which is a child care resource and referral organization. That every community has one of these. So if you don't know who your CCR&R is, that would be a great thing to Google and find out how you can connect families to subsidized childcare. But anyway, her CCR&R told her that families and children experiencing homelessness get priority enrollment. So they don't have to be put on the waiting list. And this is the policy in many states. They just need a letter from the school district homeless liaison verifying the student's McKinney-Vento status. Now, the student asked you to provide this letter to the CCR&R, but you're not sure if FERPA allows that because, of course, her parents are not going to consent to this because we know that they're very angry with all of us at this point. So what do you think? Do you think that you can provide the letter about her being a McKinney-Vento unaccompanied youth to the CCR&R? Let's see what you think about this one. This is kind of taking us back to that question about the maternity group home as well. Can we take the birth certificate out of her education record and provide it to the maternity group home? Can we provide this McKinney-Vento letter to the CCR&R? I see that most of you have voted, so I'll give you just a few more seconds before I close the poll. All right, ending poll. So most of you said yes, you can provide the letter to the CCR&R. Quite a few of you also were not sure, which again is great because that's why we're here. And let's see what the next slide says. So a couple of things. First of all, there is a requirement for the liaison to ensure that families and children experiencing homelessness can access Head Start, early intervention, other preschool programs. So it doesn't specifically say childcare, but there is this requirement that you are supposed to help your families, or in this case, your student, be able to access programs for early childhood. We also have to remove barriers to identification, enrollment, and retention in school. And if this student doesn't have childcare, I don't know how she's going to be able to come to school without childcare. So actually connecting her with childcare is helping to remove a barrier to her enrollment and retention in school. So as a liaison, you're doing a couple of things here that you are required to do under McKinney-Vento. So that helps you out and that provides you with some sort of legal cover. But also under FERPA, which is the Family Educational Rights and Privacy Act, when you have an unaccompanied youth, the Department of Education actually has issued guidance stating that schools can provide FERPA rights to minor students. So in this case, since she is an unaccompanied youth, she can go ahead and consent and say, yes, this is, private educational information, but I give you permission to release this to the maternity group home or to the CCR&R or to some other person or agency. So the student actually can do this herself. She can go ahead and consent to that information being released. The one thing to keep in mind, and I didn't say this on the slide, so we're okay, but if her parents have specifically said no, if they had specifically said, do not provide any information to the CCR&R, in that case, the parents' rights do trump the student's rights until the student turns 18. When she turns 18, then she's in charge. So you do have a little bit of FERPA complications sometimes when you have a parent who is present and who is specifically saying, no, I do not consent to that release of that information. That can get tricky, but that was not the situation that we had here. And again, you also are helping to eliminate a barrier to retention in school. So I would say that the McKinney-Vento Act actually requires this assistance and the sharing of information for the student. So before we move on to the next part of this scenario, I would love to take a look at questions. I'm going to open up the questions here. What happens after the 90 days? So let me hop back because that was Head Start. So again, if this Head Start program is run by the local school district, they're going to have to follow McKinney-Vento, and so the 90 days doesn't even apply. But let's assume that it's not. Let's assume that it's just a private Head Start program. So technically after 90 days, if they weren't able to either start the immunizations or get immunization records after 90 days for a Head Start program, they would be able to potentially exclude the children. But because Head Start works so closely with families, it's so unusual not to be able to at least get the process started after 90 days. Really, the Head Start programs do a really great job at helping to connect families to those resources. So I think it's not really a particular issue. By 3 months, they've at least been able to get a first dose or been able to get the records usually. We have another question. I've had many of these cases, but since parents have full custody, they have the last say, or does that not apply? And so let me go back also to that slide to just show you. Here we go. So So in the fourth bullet there, the McKinney-Vento Act requires schools to give priority to the wishes of unaccompanied youth in regard to school selection and enrollment. That is the rule under the McKinney-Vento Act. So it really doesn't matter. The parents may still have full custody. They certainly still have legal responsibility for their child. But the McKinney-Vento Act does give the right to unaccompanied youth to make their own educational decisions. So that's why I said, the parents probably aren't going to like that. They're probably not going to understand it. You're going to have to explain to them what the law says. I've been involved in situations like this and the parents, they're not happy. And so one thing to do is to help to connect them to other community resources, family mediation resources. They can all come in and have a conversation with the school counselor or a school social worker. So you can try to make it clear to them that you're taking their concerns seriously. But the bottom line under the federal law is that schools are required to give priority to the wishes of unaccompanied youth. And that's very specifically in the law. So that's confusing and tricky, but that's where that comes down. And just to clarify again on that Head Start piece, if it is a Head Start program that's run by a school district, the 90 days does not apply. That is correct. There is no limit in the McKinney-Vento Act on enrollment without documents. So if this had been a school district program, the 90 days would not apply. It only applies because it is a Head Start program. So let's see, we've got another question here, and I think that might be our last one. Are liaisons allowed to provide a family a homeless verification letter in order for them to apply for a homeless program through an outside agency? Absolutely. Absolutely. I mean, you can provide a homeless verification letter for any purpose at all if the family requests a letter. The issue really with our scenario here, and let me jump forward. The issue with our scenario is if the Family Educational Rights and Privacy Act, or FERPA, would allow you to release that letter without parental consent. If the parent consents, then 100% all the time, you can provide that verification letter for whatever reason they want. They don't even have to have a reason. They can just say, I want a letter that says my child is McKinney-Vento, and you just give it to them. The question here was, can the youth do that? Can the youth provide that kind of consent without a parent? And the answer, of course, is yes, the youth can. All right, so I think that we have gone through all the questions we have so far. Please keep your questions coming in. I'm going to go back into our scenarios here and keep us moving forward, but you can ask questions at any time. And again, Karen has put the link for this PowerPoint into the chat, so you're welcome to download the PowerPoint too. But let's keep going with our same scenario. Now this student would like to apply for SNAP benefits for herself and also, for her child when her child is born. Her parents have been getting SNAP benefits for her, but now she would like to get those benefits in her own name because she's not living with her parents. The student was told that she either has to be on her parents' SNAP case or she has to apply with one of the families that she's been couch surfing with, even though she's only been with them, for a few days, bouncing from place to place. She also was told the SNAP worker had to call Child Protective Services if she applied for any benefits at all. So let's do another poll here. What do you think? Do you think that she can receive SNAP benefits on her own? SNAP, of course, Supplemental Nutrition Assistance Program, also known as food stamps. Most of you are answering, and most of you already know the answer, I see. So I'll give you just a few more seconds to answer, and then I'll share the results. Okay, so most of you said yes. A few of you are not sure, but most of you said yes, and you are correct. The answer is yes. And let's see what you have in your toolbox around this. So the U.S. Department of Agriculture actually put out a brief. It's a little bit old now. I want to say it was 2013. I could be wrong about that, but it's about 10 years old, but it's still completely accurate and valid. And their brief is very specific about how unaccompanied youth can get SNAP benefits on their own. So first of all, there's no age limit on SNAP. There's no minimum age. U.S. people at the SNAP office absolutely do not have to contact Child Protective Services because an unaccompanied youth applies for SNAP. They should not be doing that. There's no reason for them to do that unless, the person ends up starting to disclose a bunch of information about abuse, but I don't know why you would do that at the SNAP office. So no, they should not be contacting Child Protective Services. What the USDA has clarified is that any household can apply for SNAP benefits. And a household means people who purchase and prepare food together. So in this case, with this student, she is not purchasing and preparing food together with her parents anymore. She doesn't live with them. So the household is not about biological relationship. It's about who you eat with. So she's not eating with her parents, so she doesn't need to be on their case. All these families that she's couch surfing with, the question would be, are they purchasing and preparing food together? It sounds like they're not, because she's been bouncing around from place to place. It's not very stable. It does not sound like the kind of relationship where she's, living almost in a host home kind of environment where everyone is eating together and they're really kind of making her part of the family. That's not what it sounds like. So in that case, if she is purchasing and preparing food on her own, then she's a household of one, and she can apply for SNAP as a household of one. And it doesn't matter where she's living or who she's living with. And when she has her baby, there'll be a household of two then. The only exception to that would be if she's staying with someone who is exercising parental control over her, which means basically exactly what it sounds like. It means somebody is acting like a parent. They're telling her to take out the trash and do her homework and what time she needs to come home, and, basically acting like a parent. If that's the case, then they're probably purchasing and preparing food together anyway. So she's going to be a part of that household anyway. But that doesn't seem to be what her situation is. Her situation seems to be just, a few nights here, a few nights there, bouncing from place to place. She would be a household of one. Many states also issued their own brief once this USDA brief came out. So some of your states might have something very similar, but even if they don't, it doesn't matter because SNAP is a federal program. So it's really whatever USDA says that goes. So you can take a look at that brief and get some more information on that one. One other piece for this particular student, I think this is our last one on this scenario. The student completed her FAFSA as an independent student due to her being an unaccompanied homeless youth. She's looking forward to graduating and continuing into post-secondary education, but the college of her choice is now demanding proof that she is homeless and unaccompanied. And the financial aid administrator at her college says a letter from the McKinney-Vento liaison is not enough. So what do you think? Is the letter from the McKinney-Vento liaison enough? Everybody knows this one. I'm getting 100% of correct responses so far. But we do have some very late breaking updates on this to share with you in the next slide. So you will learn something new, I think. All right, most people have voted. I'll give you just a few more seconds and then I'll close the poll. Okay, yes, the letter from the McKinney-Vento liaison is enough. And let's see what we have in our toolbox. So this one's really clear. The Higher Education Act gives McKinney-Vento liaisons the authority to verify homelessness for the purposes of financial aid. It's actually in the law. It's also in what is called the AVG, which is the Application and Verification Guide, which is like the guidance that all financial aid administrators have to follow. So this is really clear. But the other thing that we want to let you know is just last week, the US Department of Education came out with a letter on some new FAFSA rules. And they put some really good stuff in this letter. First of all, they are very clear again, the financial aid administrators must accept as adequate documentation from one of the entities authorized to verify a youth status. So in other words, if the liaison says this is an unaccompanied homeless youth, the financial aid administrator must accept that. They actually can't second guess it unless there's some documented conflicting information. So not just, I don't like that answer, or I don't think that answer is true. They actually have to have some documented conflicting information to show that the student is not an unaccompanied homeless youth. In the absence of that, they must accept that documentation. The other thing that we want you to know is that I'm going to go to the bottom of this slide first. There's a bunch of new authorities that are authorized to make that determination. So the liaison, you all have been able to do that since back in 2008. That's not news. So school district or charter schools liaisons, also directors or designees of shelters have been able to do this for many years, but now the law has changed to broaden the kinds of shelters that can make this verification. So really any shelter, street outreach program, drop-in center, or any program serving individuals experiencing homelessness. So before they had to be either a HUD shelter or a Runaway and Homeless Youth Act shelter. That's gone now. It can be any shelter, any drop-in center, any organization that is serving youth or individuals experiencing homelessness. So that's new. Another new addition is anybody working or director of a TRIO or Gear Up program is also now on the list. So again, if anybody on that list submits a letter saying that the student is an unaccompanied homeless youth, the financial aid administrator must accept that determination. The other thing we want you to know that was in this letter that just came out last week is that once a youth is determined to be an unaccompanied youth experiencing homelessness once, then that's it. They don't have to re-verify that status every year. So we're just going to assume that if a student was an unaccompanied homeless youth in their first year of college, they are going to be for their second, third, and fourth year, because it is so unusual that a student would reunite with their parents and kind of move back home after they have been an unaccompanied homeless youth. It happens, it can happen, but it's much more common that they remain an unaccompanied youth than that they don't. So this new policy just kind of switches the assumption. We assume that once a student is verified as an unaccompanied youth, they're going to stay that way throughout college, so they don't have to get new letters every year. So if you provide a letter for this student now while she's a senior in high school, that status is going to stay with her for all of her 4 years or however many years of college now. So we included a link to that letter on the slide, and you can, download that and see what it says. It's not the easiest letter to understand. It's kind of long and convoluted, but the information is in there. So that is very good. All right, we're going to go on to a new scenario, but before we do that, I'm going to jump back into the questions box and see what we have here. All right, someone is saying a student turns 18 during the school year. They want the school to remove their parents' information from the school computer system and request that the parents not be notified of educational information. But the student was a dependent on their income tax for their parents. This is a great question. It's really complicated. I like this one. Once a student turns 18 under FERPA, the student is in charge of all of their own educational information. So when that student turns 18 and says, I don't want my parents to access any of my information, then you actually cannot provide information to the parent because the person in charge, which is the student at that point, has said no. There is something in FERPA that says that when a student is a dependent on a parent's income taxes, that parents, that schools may release information to parents. But now you've got a may and a shall conflicting with each other, right? You have the student who is legally has the rights over this information saying, no, do not release this to my parent. So you really want to go with the shall and not the may. If the student didn't say anything about, I don't care if you release the information to my parents or not, I don't have an opinion on that, then you may release the information if the student's a dependent. But you really want to go with the shall. So in this case, if the student's saying no, you do not want to release that information to the parent. And also, one thing that I often ask too is, like, how do we know that they were dependent on their taxes? I don't know if the parents are coming in and providing their tax returns to the school. Maybe they are. But in any case, you want to go with the student's wishes. I mean, we have a couple of FAQs on this on our website as well to get more information on that one too. What sort of information should be included in a letter regarding a family who wants to have their status as McKinney-Vento verified for some kind of other program? Usually those letters are very brief. We have some samples. Let's see, let me go back here. This last bullet where we have FAFSA resources on our website, we have a lot of sample letters that you can use. It usually just has your letterhead, the student's name, maybe date of birth, and just saying basically, yes, I have identified this student as an unaccompanied homeless youth, or I have identified the student as a McKinney-Vento student, and that's it. You certainly wouldn't want to go into a lot of personal information about what's going on, with that student or family. So it can be pretty brief. Okay, so I think this question is about SNAP. It's about do students qualify if they do not have legal immigration status? That's a great question. So for anything related to education, immigration status is irrelevant. And actually, you can't even ask about immigration status. So any of the things that we were talking about, school, early Head Start, all of that educational related, immigration is not going to matter. But for SNAP and also for childcare, immigration status does matter. Immigration status also matters for federal financial aid. And so undocumented immigrants will not be able to access financial aid or childcare or SNAP benefits. But one thing to keep in mind is the relevant immigration status is the status of whoever is benefiting from the service. So for example, for childcare, if the child is a US citizen or legal resident, it doesn't matter if their parent is not, they can still get childcare. Same thing for financial aid. If the student is documented and is a legal resident or a citizen, it doesn't matter if their parents aren't, because it's the student who's going to be getting the financial aid. So keep that piece in mind as well. Here we have someone saying, here in New York, they have told youth that they have to petition the parent for child support for the youth. And many of our youth have been denied SNAP because they have a part-time job. So yeah, youth don't have to petition their parents for child support in order to get SNAP. So that is not correct. If the student's income is high enough, they might not be eligible income-wise. So I don't know how much they're making at their part-time job. They would have to be making pretty good money at a part-time job to not be eligible for SNAP. But I don't want to say 100% that they're eligible, because if they're making too much money, they would not be eligible. You ask, is there someone on the state level instead of local that can assist in these cases? I do think it's a really great practice to go to whoever is kind of in charge at the county office level or at the state office level, and talk to them, show them that USDA brief. Like I said, that USDA brief is 10 years old now. So anybody who's new might not have seen it, and they legitimately just might not know that that's out there. So I think taking that to your county office, to someone in charge at the county level, or even to the state level, and trying to get the state to put out some guidance, just echoing what that federal guidance said, could be very helpful, because it sounds like you're running into a lot of problems. Let's see, one other question. I have a student that graduated high school in Mexico. He and his sister came to our school district, where the sister is finishing her senior year. They are unaccompanied. A FAFSA letter has been provided for the sister. The brother would like to apply to colleges and does not have a single college in mind. Can we provide the FAFSA letter for him as well? So a couple of things. I mean, I'm going to assume just because they graduated high school in Mexico does not mean they're undocumented. They do have to have the appropriate legal status to get federal financial aid. So let's assume that they do have that appropriate immigration status to get federal financial aid. In that case, you're technically, the student is supposed to be enrolled in the school system for you to provide that letter. But you also could provide a letter, not necessarily as the liaison particularly, but just as a person who knows this family. So you could say, you could write a letter that says, this student is not enrolled in my school district. His sister is. I have identified his sister as an unaccompanied youth. From what I know about him, seems to me that he's an unaccompanied youth too. And he could take that to the financial aid administrator, and the financial aid administrator would make the determination. So remember, if a person can't get a letter from any of these other authorities, the very last bullet on this slide said the financial aid administrator can make the determination. So your letter could be a supportive letter. It could be a tool that he could bring into the office and say, look, technically I'm not enrolled in the school district, so technically the liaison cannot write a letter for me, but she's writing this just as a letter of support. And so would you consider me an unaccompanied youth? And the financial aid administrator can make that determination. We have another question. Can a student who's a senior now, is not homeless now, but was previously, maybe in 10th grade, receive a verification letter? So for the FAFSA. So for the FAFSA, the student has to be an unaccompanied homeless youth in the year in which they're submitting the FAFSA. So sometime between July, I think it's July 1st of 2022, and then July 1st of 2023. So if they were homeless unaccompanied youth a couple of years ago, they would not actually be able to submit the FAFSA as an unaccompanied homeless youth. They can still submit it, of course, but they're back with their parents now. They would need to provide their parents' income information in that signature. All right, I'm going to move on to a couple of other scenarios, and then we will get back into the questions pane again. So please keep your questions coming in. A new scenario now. We have a student whose parents kicked him out of the house after he came out to them as gay. He's staying temporarily with a friend's family just outside his district boundaries. Here we go again. His parents told his school of origin they don't want him participating in any activities. And also the State Activity Association says he can't play because he's living outside the district. Now he's starting in the school play. He's on the baseball team at his school of origin. He really wants to continue in these activities. So let's look at what is in your toolbox. Okay, so first thing, we've talked about this before, the McKinney-Vento Act requires schools to give priority to the wishes of the unaccompanied youth in regard to school selection and enrollment. And remember that enrollment is defined as attending classes and participating fully in school activities. So again, under the law, the parents are not going to be very happy with this probably, but the law does require the school to give priority to the wishes of the unaccompanied youth in regard to enrollment, which includes participating fully in school activities. So the student wants to participate, we're going to have to go ahead and let him participate in his activities. There's also requirements in McKinney-Vento to make sure that students can participate in athletics as long as they meet whatever academic standards there are, and certainly obviously that they actually know how to play the sport, that they don't face barriers to accessing these activities. So obviously he's a good baseball player because he's been on the baseball team since before he was experiencing homelessness. He's been in the school play since before he was experiencing homelessness. He wants to continue in those. So we need to make sure that he does not face barriers to continuing in those activities. The law also requires us to remove barriers to enrollment and retention in school. And we know that he desperately wants to continue in these activities. If he cannot be in the activities, that could be a barrier to him staying in school. So the other thing you need to know is that all these bullets on this page obviously apply to school districts and charter schools, but they also apply to the State Athletic Association. So there was a Supreme Court case a few years ago, I'm trying to remember the name and it has escaped me, but there's a Supreme Court case that basically said that your state school athletic association is so closely tied to school that it basically acts like a school in a way. And so it's going to be subject to all the federal laws that schools are subject to. So the McKinney-Vento Act applies to the State Athletic Activity League the same way that it applies to a school district or a charter school. So when we say that we have to remove barriers to accessing activities, that's not just the school district or the school that has to remove that barrier. It's also the State Athletic Association. So someone is going to have to sit down with them and explain to them, this is a McKinney-Vento student. Remember, who has the legal authority and responsibility to determine that a student's McKinney-Vento? It's the liaison. So if the liaison says that this student is a McKinney-Vento student, then we're going to have to eliminate the barrier to him participating in baseball and in the school play. So it doesn't matter that he's living outside the district. He's going to that school because it's his school of origin, and so he's going to have the right to participate. Also, there have been legal cases about this athletic issue, and in every one that I'm aware of, the student has won every time. We have some briefs on this that you can take a look at. Excuse me. We also can share copies of some of the legal briefs and decisions that have been out there. So if you have this coming up in your work, you can feel free to take a look at our full participation brief and also just email us and we can send you some more information on this. Another question always comes up too about liability. So if the parents say, oh, we don't want him to participate in baseball and then he's in a game and he breaks his ankle, is the school district going to sue you because he broke his ankle playing baseball when they told you that they didn't want him playing baseball? What you really need to know here is you just want to exercise reasonable care. Anybody can be sued at any time for anything. We all know that. So yes, the parents could sue you for any number of things if they wanted to, but the question is, would they win? And if the school or the school district is exercising reasonable care, then they're not going to be found negligent or liable. So, and that's true for anything. If the activity bus on the way home from the game gets in an accident because the bus driver was, under the influence or had all this terrible driving record and the school district let him drive the bus anyway, that's not a reasonable care. That is negligent. On the other hand, if you're doing everything the best that you can, and the student just has an accident, because that happens, people have accidents, it's very, very unlikely that the parents would prevail in any kind of lawsuit. So that's just something to keep in mind as well. All right, let's do one more scenario and then we'll jump back into the questions. So everyone's clear now about the rights of unaccompanied homeless youth in school. We know that he needs to be allowed to play baseball. He needs to be in the school play. However, there's still some confusion about how the student can get the physical he needs to play sports, because his parents, again, they don't want him to play, so they're not going to sign for medical care for him. So here's our last poll. Can he sign for his own physical? What do you think? Okay, most of you have voted. I'll give you a few more seconds. And let's see what you had to say. This one is a little bit of a trick question. I would say not sure, but the answer may be yes, and the answer also may be no. So let's see what you have in your toolbox for this one. It's really state by state what youth can consent for medically. The majority of states, more than half of states, do allow unaccompanied youth to consent for their own routine medical care. So for most of you, the answer is yes, but it depends on what state you're in. So that's why I said not sure, because I didn't tell you on the slide what state he was in. If you click on that link on the PowerPoint, you'll be able to go to one of our documents that breaks this down state by state, and you can see what your state law is. And state laws are different too. Usually there are different standards for reproductive health. There are different standards for mental health and substance abuse. And then there's also a different standard for just routine care of any kind. So what we have on our document is routine care of any kind. And like I said, most of the time the answer is going to be yes here, but there are some places in which technically the youth cannot consent for himself. Still, even in those states, a lot of medical providers will go ahead and do a physical for someone without a parent's consent anyway. So I would say still try, even if your law says no. Because particularly for something as routine as a physical, a lot of nurses and nurse practitioners and doctors will just go ahead and do it anyway. All right, let's jump back into the questions pane and see what other questions you have. And please keep your questions coming. I don't have any other scenarios for you actually. So keep your questions coming. We'll do questions for the rest of our time together. So we have, what if the student is not McKinney-Vento, they're in foster care? Do they have the same right to participate in extracurricular activities? So for foster students, there's a part of Title I, Part A that provides foster students with particular rights. So for example, the right to stay in the school of origin, the right to immediate enrollment. And I will say you've kind of stumped me because I don't recall a particular language there about extracurricular activities, but I could be wrong. So I would want to look that up to be 100% sure, and I can do that if you want to drop me an email and remind me, because just like that these days I probably won't remember. What I'm going to do is put my email address into the chat right now. But I don't recall anything about extracurricular activities in that Title I Part A. What I would say though is, talking to the student social worker, they should not confront barriers, even if there's no specific law that says it. I know that when I was a guardian ad litem myself here in DC, I would get the judge to order whatever, my clients needed to be able to participate. If they needed, clothing, or if they needed transportation, I would just get the judge to order the child welfare workers to make sure that the student had what they needed to participate fully. So I know that they should be able to do that regardless. So if you're confronting barriers, I guess my best suggestion would be to talk to the student's caseworker or social worker and say, hey, they're trying to participate and they're running into barriers. You need to help them out. Okay, additional questions. If a student is enrolled under the McKinney-Vento Act and informs the school administration that they are afraid for their life and do not want their current school or home location released to their parents, does the administration have a responsibility to protect the wishes of the student, and/or can the liaison make a formal request on behalf of the student for the administration not to release this information? Okay, this is very complicated, so let's dig into this. Under FERPA, a parent does have the right to access educational information about their child. So if the parent comes into school and says, I'm the parent, here's my ID, I want, my child's information, you do have to provide that to them, even if the child doesn't want you to, until that child turns 18, at which time, like I said before, they control their own information. This is different because it's not about a parent coming in and wanting educational records. It's more about, the school reaching out to the parent to say, hey, did you know that your child is here at our school? So it's not about the parent coming to the school and asking for information, in which case you absolutely would have to provide the information. This is about a school reaching out on their own to contact a parent. So I would say, first of all, if a child under 18 is afraid for their life at the hands of their parents, that sounds like a child welfare call to me. It's absolutely not the case that you need to call child welfare on all unaccompanied youth. Absolutely not. But there are certain things that youth can say that are going to trigger a mandated report. And I think I fear for my life at the hands of my parent. To me, that triggers a report. So I think what you would do, what I would suggest you do there is you talk to the student and say, look, if you're afraid for your life, what I'm going to do is I'm going to make this report to Child Protective Services, and then we are not going to share your location with your parent. Because you've done a couple of things there. As a school, you've now protected yourself. If the parent tries to come in later and says, hey, you are like kidnapping my child, or you're harboring a runaway, or you were hiding my child from me, you are protected because you've called Child Protective Services. Somebody else out there in the world knows where this child is. It's not just you. So I think you've done two things. You've perhaps gotten some help that the child needs, maybe not, but at least you've kind of covered your bases around, whoa, this is a very serious situation. We're going to call Child Protective Services, and then we are not going to release, we're not going to reach out to parent and say, hey, here's where your child is, come get them. So I hope that helps. Another question. What if a student does not like the rules at home and chooses to live with a friend and the friend's parents? The student's parents want the student to return home and did not kick their child out. Is the student an unaccompanied youth? So in those situations, whenever I think that there is a youth who is not in the physical custody of a parent or guardian, and who is sleeping in a place that is not their place, so they're staying with friends, those friends' parents at any time could be like, I'm tired of you, get out. To me, that is an unaccompanied youth. To me, that is a McKinney-Vento situation. Now, some of those situations over time might not be McKinney-Vento any longer. Over time, maybe the parent and this friends, parents, maybe they sit down and they come up with an understanding and they say, you know what, actually, it's going to be much better for the student to just live there, and we have a spare room, and mom and dad are going to provide some financial support. There are ways in which that situation could stabilize over time, and over time you might say that's not a McKinney-Vento situation. But anytime that it's kind of precarious like that, where someone has run away from home, is staying somewhere where they're there now, but we don't know how long they're going to be there, and they're not in the physical custody of a parent or guardian, to me, that is an unaccompanied homeless youth under McKinney-Vento. We have a question about contacting CPS for unaccompanied youth. Is there anything written about that? So what I would go back to, let's see, let me find this. I would go back to this last bullet, removing barriers to identification, enrollment, and retention in school. If you contact CPS for every unaccompanied youth who comes to school, you're not going to have a lot of unaccompanied youth coming to school. It's going to be a barrier to identification. It's going to be a barrier for enrollment and retention, because students, for the most part, do not want to be involved in the child welfare system. They don't want to get their parents in trouble. They don't want to get their siblings involved. There's lots and lots of reasons why they just don't want anything to do with that system. And so kind of a standard operating procedure of we just report all of our unaccompanied youth would be a violation of the McKinney-Vento Act, because it would be a barrier to identification, enrollment, and retention in school. But, like I said, the exception is certainly there are going to be occasions where a youth might reveal something that is pretty extreme, like, I think my parents are going to kill me, in which case, yeah, that certainly, I think, would rise to the level of triggering a report. And what I would say is have a conversation with the student to try to mitigate that barrier, so they don't feel like you just kind of stuck up behind them and called CPS on them, but you said, hey, look, wow, what you just said to me is really scary. I'm really scared. I think that you're really scared. Here's what we need to do in this situation. We need to make this call to CPS, but we're gonna do this with you. We're gonna walk through it with you. We really want you at school. We really want you to stay with us. This is a safe place for you to be. And so, having a conversation with the student to try to mitigate what otherwise could be a barrier to identification. So in terms of what's in writing, I would say this is what's in writing, this last bullet here on the slide about removing barriers. Okay, I don't think we have any more questions. Let me show you some additional resources. Oh, I wanted to let you know about our scholarship program. Unfortunately, the current application is closed. We had our deadline just a few weeks ago, but the new application will open in June of next year. It'll be open until November of next year. So for students you have now who are juniors, keep this in mind for when they're seniors, to have them apply. There's no immigration requirement. It's a pretty easy application. And in addition to a cash award, what we provide to our students is ongoing mentorship and partnership throughout their entire post-secondary careers, throughout their transition to the workforce, or whatever comes next for them. So, you know, we have scholars that I've known since they were in high school, and now they're, you know, dentists, and they own homes, and they're married, and the whole thing. So we stick around with our scholars for as long as they'll have us. So keep that application in mind. I did want to make sure that you knew, obviously, about our website and our newsletter. On our website, schoolhouseconnection.org, we have a feature called Q&A from our inbox. Q&A from our inbox is basically just a living FAQ, which we update regularly over time. It's real questions that we receive from people like you. We take out any personal information and post those so that you can get answers. So a lot of the questions that were asked today are in that FAQ. So I would just encourage you to take a look at that. You might find answers to a lot of questions you have in that Q&A from our inbox feature on our website. So with that, I have to say, I thought that I would have more questions. You asked a lot of questions, and I appreciate that. I thought there would be even more, so I kind of deliberately padded a lot of time into this presentation for Q&A. But seeing that we don't have any more questions, I can let you all go a little early. So I really appreciate your time today. Karen has been wonderful helping out with the Q&A and with the chat box, so thank you for that, Karen. And we just appreciate everything that you all do for students and for families. So thank you for being with us today, and thank you for your time. Have a good day.